Hi everyone, I'm David Fisher, and this is Presidential Perspectives, where we take a look at current events through the lens of American history as seen through the lives of the presidents of the United States. In this episode, we focus on Obey the Courts. Now, in his year-end report on the judiciary, Chief Justice John Roberts issued a bit of a warning. He wrote that judicial independence is undermined unless the other branches of government are firm in their responsibility to enforce the court's decrees. Within the past few years, however, elected officials from across the political spectrum have raised the specter of open disregard for federal court rulings. These dangerous suggestions, however sporadic, must be soundly rejected, the warning from Chief Justice John Roberts. Well, the historical record in the United States on this topic is actually quite impressive and a key to the lasting nature of the American democracy, because in nearly all cases, the other branches of government have followed the orders of the courts. This episode is going to focus on just a couple of exceptions to that. And for that, we're going to begin going back to the presidency of Andrew Jackson. When he became president in 1829, he introduced everybody. He was going to be a different kind of president, a very strong chief executive who believed that the president is more representative of the national will than the Congress, which was an unusual statement at that time. But he would later add not just about his view between the executive and legislative branches, what about the binding nature of judicial decisions, according to President Andrew Jackson? Well, he wrote, "The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point, the president is independent of both." According to Jackson, the authority of the Supreme Court must not therefore be permitted to control the Congress or the executive when acting in their legislative capacities, but to have only such influence as the force of their reasoning may deserve. Now, many thought this was a rather monarchical statement, but perhaps not all that surprising from a man who was, when he was a general in the U.S. Army, arrested a federal judge after the Battle of New Orleans. He was trying to continue to enforce his own decree of martial law, ended up having to arrest that judge. That judge later held him in contempt of court, fined him $1,000. So you can see some of these early seeds of this kind of thought process for Andrew Jackson coming to a head now when he's president, particularly in 1832. What's happening in this very contentious year? Well, one of the things was the passage by something that was near and dear to the heart of Andrew Jackson called the Indian Removal Act, which authorized the president to disregard previous treaties with Indian tribes and open up negotiations to move many of those tribes to the west of the Mississippi River. Now, after the Indian Removal Act was passed, some of the states started to pass laws relative to these Indian tribes, again, trying to force them to agree to move, and in particular in Georgia. A law was passed that made it illegal for white men to live on land, Indian land, without a permit. Now, this led to the arrest of a missionary by the name of Samuel Worcester, and he sued in federal court because he believed that the state law violated the sovereignty of the Cherokee Nation. That suit went to the Supreme Court. Chief Justice John Marshall wrote for the opinion of the court that they agreed Indian relations, according to the Marshall Court, the exclusive province of the federal government. So these state laws can't happen. Ordered the release of the missionary Samuel Worcester. Well, the state government in Georgia refused to comply with that order from the Supreme Court, one of these rare cases in American history, but even rarer, the President of the United States refused to enforce that order as well. Andrew Jackson's focus at the time was Indian removal, not solving these kinds of problems within the state, did not feel he was bound by the courts. In fact, he was later credited with a quote from newspaperman Horace Greeley, who wrote that Jackson said that John Marshall has made his decision, now let him enforce it. Well, there's no evidence that Jackson ever said actually that, but he did say something very similar. In a letter to his friend John Coffey, Jackson wrote, "The decision of the Supreme Court has fell stillborn, and they find that they cannot coerce Georgia to yield to its mandate." So similar sentiment, and frankly, that was right, because the judiciary in the United States has no enforcement authority. The judicial branch has to rely on the other branches, like the executive branch, to actually enforce their orders. And in this case, that wasn't happening. So Worcester actually sat in prison for over a year while the Trail of Tears under Andrew Jackson got underway, that brutal and deadly march of many of those Indian tribes to the west of the Mississippi River. Now, on the good side, this did not really set a precedent because there was no other president that picked up this notion of ignoring orders of the courts. There's really only one other example based on my research in American history where that happened, and that was at the beginning of the Civil War, and the president was Abraham Lincoln. Now, in this case, Abraham Lincoln, shortly after the fall of Fort Sumter, this is April of 1861, ordered the volunteers to come forward from the north, about 75,000 troops, to be able to suppress this rebellion. Well, there was chaos going on in and around the Capitol. The Confederates are forming on the other side of the Potomac River, and it was difficult to get those soldiers, those volunteers, to get to the U.S. Capitol because some choke points had developed, particularly in Baltimore, which was a Confederate sympathy hotbed, and there was violence going on in Baltimore just trying to get those troops in place. So what did President Lincoln do? Well, he gave an order to the commanding general, Winfield Scott, to suspend the writ of habeas corpus and to arrest anyone who was deemed in rebellion against the United States. They could be arrested, held without charge, no access to federal courts because the writ of habeas corpus had been suspended. Well, one of the first people who was arrested along these lines was a man by the name of John Merryman. And John Merryman was actually in the process of training some troops in the state of Maryland to presumably to go and support the Confederacy. He was clearly in rebellion, so he was arrested under this order. Well, Merryman sued for his right to appear in a federal court, not to be held in a military prison, and in stepped Roger Taney, who was the Chief Justice of the Supreme Court at the time, actually in this case sitting in his role as the circuit judge over the circuit in which Merryman was arrested. He looked at the case and he issued an order that Merryman needed to be tried in a federal court or released. Well, in this case, the jailer, the military jailer, refused to even bring that note into the jail. The President of the United States, Abraham Lincoln, ignored the order of the court in his right as the commander-in-chief in this time of rebellion. Well, what's the rules about all this? How does it all play out? We look at the Constitution itself. Article 1, Section 9 has a provision for this kind of circumstance. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. Well, clearly there was a rebellion going on right now, so why did Chief Justice Roger Taney reject Abraham Lincoln's decision to ignore his order? Because Taney points out that this was in the Constitution in Article 1. That meant it was Congress's power, not the president's, to suspend the writ of habeas corpus. That had not happened yet, and when his order was ignored, the Chief Justice was frankly exasperated. He wrote that these great and fundamental laws have been disregarded and suspended, like the writ of habeas corpus, by a military order supported by force of arms. I can only say that if the authority which the Constitution has confided to the Judiciary Department and judicial officers may thus upon any pretext or under any circumstances be usurped by the military power, at its discretion the people of the United States are no longer living under a government of laws. What could he do? Well, frankly, nothing, because again, the judiciary does not have any powers of enforcement. They need the executive branch to do that, and the executive branch wasn't complying. So what did President Lincoln say about all of this? I mean, he gave his explanation. Now it is insisted that Congress and not the executive is vested with this power, but the Constitution itself is silent as to which or who is to exercise the power, and as the provision was plainly made for a dangerous emergency, it cannot be believed the framers of the instrument intended that in every case the danger should run its course until Congress could be called together, the very assembling of which might be prevented, as was intended in this case by the rebellion. Now, honest old Abe got that nickname for a very good reason. For the most part, he was as honest as the day is long, but in this case, maybe one of the most disingenuous statements Abraham Lincoln had ever made. Now, we talk a lot more in detail. You can go check out the links in the description of this particular episode to earlier episodes of Presidential Chronicles. We're going into great detail about why this power to suspend the writ of habeas corpus was clearly in the responsibility of Congress. Now, Congress actually met a couple of months later after the suspension by Lincoln, and they approved many of Lincoln's war-making requests, but they did not agree to suspend the writ of habeas corpus. In fact, they didn't do that for 2 more years, and in the meantime, the Lincoln administration had arrested some 10,000 American citizens, holding them without charge, no access to federal courts. Once again, Lincoln spoke quite quite calmly or seriously about the special circumstances on why this time was different. Lincoln said, "Was it possible to lose the nation and yet preserve the Constitution? By general law, life and limb must be protected, yet often a limb must be amputated to save a life. But a life is never wisely given to save a limb. I felt that measures otherwise unconstitutional might become lawful by becoming indispensable to the preservation of the Constitution through the preservation of the nation. Right or wrong, I assume this ground and now avow it." In his mind, in this case, the end clearly justifies the means. Many political enemies came out against Lincoln at the time, claiming him to be a monarch, a despot. He held his ground. Once again, though, this did not really become a precedent. Unique circumstances, no other precedent really followed. And in fact, we move forward nearly another century later when a couple of states tried to ignore the orders of the court, and 2 presidents firmly shut that down. Specifically, this was in the wake of the decision by the Warren Court, 1954, where they struck down the concept of separate but equal in their decision in Brown versus Board of Education, which required desegregation of the schools across the country, particularly in the heavily segregated South. Now, President Dwight Eisenhower at the time was not a big fan of this decision in Brown v. Board. He believed more in evolution rather than revolution when it came to imposing social change quite abruptly, but when the court spoke, he was quite firm in what he was going to do. According to President Eisenhower, the Supreme Court has spoken, and I am sworn to uphold the constitutional processes in this country, and I am trying. I will obey. Well, a handful of states balked, beginning with Arkansas. Now, after the Little Rock School Board announced plans to open Little Rock Central High School to black students as of September of 1957, some of the parents in that school went to a federal court to seek an injunction to basically say not to allow this, and that request was forcefully denied by a federal judge by the name of Ronald Davies. Now, the governor of Arkansas, in quite defiance of this order, called out the Arkansas National Guard to actually prevent the entrance of the so-called Little Rock Nine, the 9 black students who were trying to join Central High School, and they were blocked by the Arkansas National Guard. What happened next? Back to federal court. Judge Davies said can't do that. He ordered the Arkansas Guard to be removed. In the meantime, President Eisenhower did meet with Governor Faubus, and he warned him, if you're challenging the federal government in this one, you will lose. And so what did Faubus do? Well, he removed the National Guard, but then a mob basically took its place on the grounds of Central High School to keep the Little Rock Nine out, at which point the mayor of Little Rock, William Mann, said, look, I can't protect the peace anymore. President Eisenhower, I need your help. All eyes were on Washington now. This is not the way President Eisenhower wanted any of this to go down, but he struck to a core principle. And in this country, we followed the orders of the courts. He ordered the 101st Airborne Division of the United States Army immediately to descend on Little Rock, clear a path for the Little Rock Nine into Central High School, and he went on television from the White House to explain what he was doing and why. According to Eisenhower, the very basis of our individual rights and freedoms depends upon the certainty that the president will enforce the decisions of the courts. Unless the president did so, anarchy would result. Mob rule cannot be allowed to override the decisions of our courts. A foundation of our American way of life is our national respect for the law. The troops are there solely for the purpose of preventing interference with the orders of the court. It was successful. The crisis was over. The rule of law prevailed, thanks in large part to a president who stuck to this core principle that in this country we do obey the orders of the courts. Now, in the next administration, John Kennedy's administration, which I'm looking forward to studying in much more detail for my next book, had a similar stand in a couple of cases, again, related to the desegregation order from Brown v. Board, once again standing up to those obstructions, once again enforcing the orders of the courts. Now, the history on this topic, John Roberts' warnings notwithstanding, is actually pretty clear. Just 2 notable exceptions in more than 230 years under the U.S. Constitution where the President of the United States has ignored the order of the courts. All other cases, pretty impressive example of where the presidents, the executive branch, have obeyed the courts. And as President Eisenhower said, it's a core foundation to American democracy. And again, the warning from John Roberts talking about this, needing it to continue to keep that democracy in place. That is the history of Obey the Courts. For more on this issue, check out some of those videos in the links in the description here. You can also read my books on Amazon.com, and don't forget to subscribe to this YouTube channel. Until next time, I'm David Fisher. This is Presidential Perspectives from Presidential Chronicles.